Hello and welcome to the Minimum Competence episode for Wednesday, March 19th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, a judge blocks Elon Musk's USAID cuts, Trump's push to deport a Columbia student protester, Chief Justice John Roberts' weak response to Trump's attacks on judges, and my column on grocery taxes. Let's remember, a corporation is an ingenious device for obtaining individual profit without individual responsibility, and read today's legal news. On this day in legal history, March 19, 1931, Nevada Governor Fred B. Balzar signed a bill legalizing gambling, a decision that would reshape the state's economy and identity. At the time, Nevada was struggling through the Great Depression, and state lawmakers saw legalized gambling as a way to generate revenue and attract tourism. The measure made Nevada the first U.S. state to formally embrace commercial gaming, setting the stage for the rise of Las Vegas as the world's gambling capital. Initially, the law allowed for small-scale gaming operations, but over time it evolved into a massive industry. In the 1940s and 1950s, organized crime syndicates invested heavily in Las Vegas casinos, fueling both the city's expansion and its reputation for vice. By the 1960s, corporate interests took over, bringing legitimacy and regulation to the industry. Today, Nevada's gaming industry generates billions in revenue and remains a cornerstone of its economy. The legalization of gambling also influenced other states, many of which later followed Nevada's lead by authorizing casinos and lotteries to boost their own economies. However, the decision was not without controversy. Critics argued it would lead to crime and social problems. Despite these concerns, the success of legalized gaming in Nevada proved that, with regulation, gambling could be a major economic driver. Governor Balzar's decision on this day in 1931 not only changed Nevada, but also helped shape the broader American gaming industry, making March 19th a landmark date in legal and economic American history. A federal judge has halted Elon Musk and the Department of Government Efficiency, or DGE, from further efforts to shut down the U.S. Agency for International Development, or USAID, ruling that their actions likely violated the U.S. Constitution. Judge Theodore Chuang's preliminary ruling orders the restoration of USAID employees' computer access after Musk and DGE had placed thousands on leave and blocked agency systems. The lawsuit filed by USAID employees argues that Musk unlawfully took control of the agency without Senate confirmation, exceeding executive authority. President Trump, who has appointed Musk as an advisor, responded by vowing to appeal, calling the ruling an example of judicial overreach. While Chuang agreed that Musk's actions were unconstitutional, he did not reverse the termination of USAID contracts, which had already crippled global humanitarian operations. In a related case, another judge ordered the administration to release $671 million in frozen payments to USAID contractors, though the government has delayed full compliance. Secretary of State Marco Rubio confirmed that over 80% of USAID's programs were being eliminated. A federal judge rejected the Trump administration's attempt to dismiss a legal challenge brought by Mahmoud Khalil, a Columbia University student arrested by immigration authorities for his role in pro-Palestinian protests. However, Judge Jesse Furman ruled that he lacked jurisdiction and transferred the case to New Jersey, where Khalil was detained when his lawyers first filed the challenge. The ruling did not address Khalil's request for bail. Khalil, a lawful permanent resident of Palestinian descent, was arrested on March 8th outside his Manhattan residence. His lawyers argued that his detention was retaliatory and violated his First Amendment rights. The Trump administration has justified his removal under a rarely used provision of the 1952 Immigration and Nationality Act, allowing deportation if a non-citizen is deemed a threat to U.S. foreign policy. Secretary of State Marco Rubio cited Khalil's participation in, quote, pro-Hamas events as justification, though Khalil denies any ties to Hamas and claims he was a mediator in the protests. Legal experts note that this law was previously ruled unconstitutional by the late Judge Marianne Trump Barry, though that decision was later overturned on a technicality. Khalil's case has become central to debates over immigration enforcement and free speech, particularly as Trump pushes for deporting non-citizens involved in campus protests. Chief Justice John Roberts issued what can only be called a mild rebuke to President Donald Trump for calling for the impeachment of a federal judge, stating that impeachment is not an appropriate response to a judicial ruling. While Roberts' statement affirms judicial independence, it does little to address the broader issue. Trump's rhetoric is not just about disagreement with a ruling, it is part of a broader effort to delegitimize the judiciary and erode checks on executive power. Roberts has a history of making these kinds of statements, such as in 2018 when he made the remark, "We do not have Obama judges or Trump judges." But mere words are insufficient when Trump and his allies actively undermine the rule of law. The administration's refusal to comply with Judge James Boasberg's order halting deportations under a rarely used 18th century law is more than a policy dispute. It is an act of defiance that inches towards constitutional crisis. If the court's authority is disregarded, the judiciary's power is only as strong as its willingness to enforce its rulings. Trump's call for impeachment is not an isolated outburst. It coincides with a broader push by his allies, including Elon Musk and congressional Republicans, to frame judges as enemies of democracy. Given rising threats against judges, the Chief Justice's response should have gone beyond a procedural reminder to file an appeal. A firm defense of judicial enforcement and the rule of law, backed by action from the courts, is needed because if the judiciary allows itself to be treated as an advisory body rather than an independent branch of government, mere statements will not protect it. And in my column this week, I talked about grocery taxes, or more accurately, their potential elimination in some states. With grocery prices remaining high, some states are considering eliminating grocery sales taxes entirely to ease financial burdens on residents. However, a blanket repeal could strain already tight state budgets, especially as federal funding for social programs faces potential cuts. Instead of eliminating the tax entirely, targeted approaches such as income-based exemptions or allowing municipalities to retain and reinvest grocery tax revenue offer more sustainable relief. Income-based exemptions would ensure that low-income households receive the most benefit while maintaining revenue streams for essential services. For example, Idaho already provides grocery tax credits for low-income taxpayers, and a more efficient model could exempt qualifying households from paying the tax at checkout, reducing their financial strain. This method would prevent a full repeal that could destabilize state budgets while addressing the regressive nature of grocery taxes. States struggling with budget shortfalls from past tax cuts like Arizona and West Virginia serve as cautionary tales. Arizona's 2021 flat tax contributed to a $1.6 billion deficit, forcing cuts to higher education, while West Virginia's aggressive post-pandemic tax cuts created funding gaps that could disproportionately affect vulnerable populations. Removing grocery taxes without a revenue replacement could lead to similar outcomes. Alternatively, allowing local governments to retain grocery taxes and use the revenue for food assistance, childcare subsidies, or public transportation could provide relief without compromising state services. Since different municipalities have varying fiscal needs, this approach would offer flexibility while ensuring that low-income families receive targeted aid. A well-designed policy would balance tax relief with financial responsibility, preventing unintended consequences like service cuts that ultimately harm those who need the assistance most. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment and leave a rating or review on your podcast player, we'd appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, there's nothing new under the sun, but there are lots of old things we don't know very much about.